Okay, good afternoon again. You're all very welcome to today's webinar hosted by the Whitaker Institute, exploring recent developments in international law relating to aggression and its victims. My name is Professor Shane Darcy. I'm a member of staff here at the Irish Centre for Human Rights at NUI Galway, and I'm delighted to be joined by Dr. Aaron Pubg, who's a Senior Research Fellow at the Max Planck Institute, Dr. Eliev Lieblich, who's an Associate Professor at Tel Aviv University, and Professor William Shavis, well known to many here as the first director of the Irish Centre for Human Rights, now a Professor Emeritus, currently based at Middlesex University in London. Thanks very much to Courtney Yanta of the Institute for all her assistance with the organisation of the event, and to Catherine White, who is providing sign language interpretation. So in terms of the format of the session, I'm going to begin by offering an overview of two key developments in international law relating to aggression and highlighting some of the questions and challenges that these give rise to, before turning over to the other participants who will each take 10 or 15 minutes to offer their thoughts and insights, following which we'll have time for discussion and questions from the audience. Courtney has told me that there is a Q&A function available on Zoom, which we can use, and hopefully we'll be able to take some questions from the audience as well. Although the microphones are working, I think your videos won't be able to work for the webinar purposes. So to get started, just over a decade or so ago, I asked a PhD student who was studying here in Galway and writing on the topic of victims in international criminal law. I asked who would constitute a victim of the crime of aggression. This was at our annual PhD seminar, which was taking place just a couple of months before the first review conference of the International Criminal Court, where states were due to engage in a stock-taking exercise of the court and to consider issues around the definition of the crime of aggression and the exercise of the court's jurisdiction over that crime. Now, the student rightly said that the crime wasn't within the court's active jurisdiction just yet, so she wasn't going to consider it for her thesis. And if I recall, there was quite an air of pessimism at the time regarding the prospects for states to agree on a definition of aggression and when the court could exercise its jurisdiction over the crime, which they did actually manage to do in Kampala in 2010. The question was and remains an intriguing one, which the scholarship at the time had said almost nothing about. And having returned to the question more recently, I found that despite the increasing attention being paid to victims under international law, there's been relatively little consideration given to the idea that natural persons might be recognized as victims of aggression within the international legal system up until recently. There are notable exceptions, of course, to this gap in the literature, including work by speakers who are participating in today's webinar. Now, when it comes to aggression, which we understand as the unlawful use of force in violation of the prohibition laid down under the UN Charter and customary international law, victims of this internationally wrongful act are generally considered to be states. So UN General Assembly Resolution 3314, which gives us a definition of aggression from 1974, refers to the victim, singular, of aggression, taken to mean the state which has been unlawfully attacked. While the judges at Nuremberg described aggression, or the crime against peace, as it was known at the time, as the supreme international crime, which contains within itself the accumulated evil of the whole, their concern was more with the individualization of responsibility rather than identifying its victims. Now, since that time, we have seen, of course, the codification of the laws on the use of force, the emergence of international human rights law, the expansion of international humanitarian law, and the rebirth of international criminal law. And international law now pays increasing attention to the rights of victims. Two prominent examples in this respect are the 2005 UN Basic Principles and Guidelines on the Right to a Remedy and Reparations for Victims, and of course the Rome Statute of the International Criminal Court itself, which departs from the approach of its predecessor tribunals and adopts one which the judges in Lubanga said was more inclusive, encourages participation, and recognizes the need to provide effective remedies for victims. But natural persons, whether individuals or groups, have not been considered as victims of aggression in the international legal system to date. The UN Basic Principles refer to victims of violations of international humanitarian law or international human rights law. And while aggression may often entail the commission of such violations, up to and including war crimes and other international crimes, it does not, in and of itself, breach those bodies of international law. It is states who are considered traditionally to be the victims of aggression, even if there is an obvious human toll to such breaches of the jus ad bellum. However, two recent developments, which will be the focus of today's session, in international law may presage something of a departure from this traditional approach. The first is the activation of the ICC's jurisdiction over the crime of aggression in July 2018, which opens up the potential for the application of its extensive regime of victim participation and reparations to this crime. And the second is General Comment 36 of the UN Human Rights Committee on the right to life, in which the committee asserts that deprivation of life occurring in the context of an act of aggression entails ipso facto a violation of Article 6 of the Covenant on Civil and Political Rights. Now, the potential for recognizing individuals as victims of the crime of aggression at the ICC has come about somewhat accidentally, it might be said, with little attention having been given to this possibility by states who were focused instead on the definition of the crime and establishing the court's jurisdiction. In contrast, General Comment 36 can be seen as a deliberate effort on the part of the Human Rights Committee to expand the scope of the right to life to encompass as victims those deprived of life during an unlawful use of force amounting to aggression. So turning to aggression first at the International Criminal Court. The definition as agreed in 2010 is quite exacting with its reference to a manifest violation of the UN Charter, and it arguably thus limits the potential for prosecution, as does the differentiated jurisdictional regime of this crime, which effectively includes non-states parties to the Rome Statute and the aggression amendments, unless the Security Council was to refer a situation to the court. Moreover, only 40 states, most recently Bolivia, have become party to the aggression amendments, which further reduces the scope for prosecution. But nevertheless, jurisdiction is now active and prosecutions, or at the very least preliminary examinations or investigations, though perhaps unlikely, cannot be ruled out. The question of who will constitute a victim of the crime of aggression will thus inevitably arise. Now, while victims have a right to participate in proceedings and to receive reparations in the event of a successful prosecution, their interests are to be taken into account even prior to the opening of an investigation, while the Trust Fund for Victims offers assistance outside of the court-mandated reparations system. Rule 85 of the court's rules of procedure and evidence defines victims as natural persons who have suffered harm as a result of the commission of any crime within the jurisdiction of the court. It also includes organizations or institutions who have suffered direct harm to property directed to various purposes: religion, education, art, science, charitable and humanitarian purposes. Now, no attention was given to the question of who constitutes a victim of aggression in the preparatory work leading up to Kampala and to the activation of the court's jurisdiction. But a plain reading of the rules would suggest that natural persons can be victims of this crime when suffering harm as a result of aggression. And harm has been interpreted broadly in the jurisprudence to date, and thus a wide range of persons could readily be considered as victims of the crime of aggression. It could include, for example, victims of other international crimes committed in the course of aggression, perhaps even other harms not amounting to crimes, such as civilians forced to flee but not coerced into doing so, or perhaps even members of a victim state's armed forces who've been killed, even if in accordance with international humanitarian law. And as Aaron notes in her chapter on this topic in the Cambridge Commentary on the Crime of Aggression, there is a potentially massive universe of victims of aggression. And while states are seemingly excluded as victims by the rules, in the Al-Mahdi case, symbolic reparations were awarded to Mali. Now, the recent independent expert review on the ICC referred to the huge number of potential participant victims whose interests and applications must be accommodated in ICC proceedings. And this was without any consideration of the crime of aggression specifically. And cases to date have included thousands of victims. In Bangladesh and Myanmar, there's been representations made on behalf of 470,000 individual victims. So participation certainly allows for the unique views of victims to be presented and taken into consideration by the court, but it also creates a significant administrative burden. So in addition to the use of common legal representatives, the court has sought to streamline various aspects of this process, and the review has made further recommendations in this regard. It's in the context of reparations, however, that aggression may present the most significant challenge, given the likely high numbers on the one hand and the limited funds available on the other, notwithstanding other serious shortcomings relating to reparations as highlighted by the independent expert review. So most defendants have been declared indigent. The finances of the Victims' Trust Fund are not in great shape. The award against Lubanga was $10 million US. The trust fund generally receives around 4 million annually in contributions and holds around 9 million in reserve a couple of years ago. In comparison, the UN Compensation Commission, which dealt with Iraq's invasion of Kuwait, had 1.5 million claimants and awarded 50 billion US dollars in compensation. So in the context of aggression, it may be that the court is only able to offer symbolic reparations of limited tangible benefit for victims, and therefore it prompts reconsideration of the question as to whether criminal prosecutions and reparation processes perhaps should be institutionally separate at the international level. Just to turn now to General Comment 36 of the Human Rights Committee from October 2008. In paragraph 70, the committee stated that states, parties engaged in acts of aggression as defined in international law resulting in deprivation of life ipso facto violate Article 6 of the Covenant. Now, while the committee has emphasized the risks to the right to life presented by war and aggression in its two previous general comments on the right to life, this is a new position which adds an extra dimension to the long-standing discussion on the role and application of human rights law in times of armed conflict. While it is largely settled, at least for many international courts and other bodies, that human rights law applies in times of armed conflict, debate continues regarding the scope of extraterritorial obligations in particular, as the recent European Court of Human Rights judgment in Georgia versus Russia so readily demonstrates. Now, notwithstanding, human rights law and humanitarian law are broadly seen as being complementary, not mutually exclusive, in the words of the committee. And for the committee, determining whether someone has been arbitrarily deprived of their life may require resort to international or domestic law, and up until recently, when it referred to international law, it really meant international humanitarian law. With General Comment 36, the committee has adopted an approach that has long been advocated by Bill Shabas for many years, that arbitrariness should also be assessed with respect to the applicable jus ad bellum, to the law governing the use of force. Now, there's two other pillars to paragraph 70, which Eliev discusses in his forthcoming European Journal of International Law article, and which he may touch upon in his remarks. But in relation to the sentence which I just read out in relation to violations of Article 6 in the context of acts of aggression, this position by the committee was not supported with any reference to previous general comments or to concluding observations that it had issued in relation to states. And it was contested by several states during the drafting phase. So just to give you a flavor, Canada urged that humanitarian law was the relevant lex specialis. The France submission and the UK suggested this paragraph should be omitted from the general comment. Germany recognized that human rights may be violated during aggression, but it favored a clear distinction between relevant legal regimes. The United States, perhaps unsurprisingly, attacked the paragraph on several fronts, including by stating that it was the role of the Security Council to determine the existence of aggression, notwithstanding, of course, the role of the ICJ and the ICC in this regard. But the committee didn't fold to these criticisms and retained what Roger Clark described as the striking proposition of paragraph 70. Now, general comment also includes an elaboration of the committee's understanding of jurisdiction that goes beyond situations of effective control of territory or authority and control over persons to include situations where the right to life is impacted by a state's military or other activities in a direct and reasonably foreseeable manner, perhaps to accommodate paragraph 70. So what does this mean then for the work of the Human Rights Committee? Something which Eliev will talk about also. The committee, in contrast to the ICC, is concerned with state responsibility rather than the arguably more exacting strictures of individual criminal responsibility at the ICC, where the focus is on the crime of aggression, whereas the committee is focusing on the act of aggression. But the law on the use of force may go beyond the expertise of its members, as some of them have recently admitted. The focus is also narrower than the ICC. It focuses only on the right to life, General Comment 36, although perhaps it may be extended to other rights where arbitrariness is also relevant, such as liberty and security of the person. And again, violations of Article 6 may seemingly arise where there is also compliance with international humanitarian law. And might that include both civilians and members of the armed forces of the victim, as well as the aggressor state? Something to be considered. General Comment 36 opens the possibility of the committee hearing individual complaints from victims of the right to life being violated during situations of aggression. Now, reparations may not be as challenging as at the ICC, given that the committee tends to defer to states in this respect, but it bears noting also that human rights bodies are not necessarily best placed to deal with large numbers of claims. Other human rights bodies, international courts, may find the committee's interpretation to be influential. Great weight is said to be attached, according to the International Court of Justice, to the views of the Human Rights Committee. And as Eliev points out in his recent article, Special Rapporteur Agnes Calamar drew on General Comment 36 to find a violation of Article 6 of the Covenant in her report on the killing of Qasem Soleimani by the United States. And there's no doubt that in the future, General Comment 36 will guide the work of the committee itself, and it will be the main body tasked with applying this quite progressive and expansive interpretation of the protections of the right to life. So both of these developments, that at the International Criminal Court, that with the Human Rights Committee, presage potentially a significant shift in the understanding of victims in the context of aggression. But they will require both institutions to negotiate and address various challenges and perhaps as yet unanswered questions. So for the ICC, for example, might it adopt a narrow construction of victims? Might states even intervene to amend the rules of procedure and evidence to facilitate such a narrow construction, which risks excluding many who have suffered harm, but given the pragmatics involved, a broad inclusive approach could further show up the limitations in relation to reparations. Recognizing natural persons as victims of aggression would reinforce the claim made by the International Criminal Tribunal for the former Yugoslavia that a state sovereignty-oriented approach has been gradually supplanted by a human being-oriented approach. I mean, this may be so, but the ICC and the Human Rights Committee operate within the parameters of the international legal system as set by states, not all of whom, as I've mentioned, are agreeable to these latest developments. So with that overview, I'd like to turn now to my co-panelists, beginning with Dr. Aaron Pubg, who will offer their thoughts and reflections on these developments, including some of the legal and other challenges that they present. So over to you, Aaron.
Okay, thank you, Shane. First of all, I would like to thank you for the invitation to participate in this panel, and also to the Whitaker Institute for hosting this webinar. I'm really excited that we're all here today discussing this important topic, and it's been so interesting to see the recent developments in international law. Before I go further, I would just like to apologize because my voice is a bit hoarse today, but I hope that I can make myself understood. I will focus my remarks over the next 10 minutes or so on the first part of these recent developments that Shane mentioned, namely victims of the crime of aggression. And I would like to really highlight the context of this and what makes the recognition of individuals as victims of this crime so significant and even radical and certainly controversial. And I will then further explain a bit more why individuals can be recognized as victims of the crime of aggression, and then highlight some of the open questions that this raises and some of the practical implications. So to illustrate the developments and how much thinking on this has changed over the last decade or so, shortly, well, a couple of years after the adoption of the Kampala Amendments, which inserted a definition of the crime of aggression into the Rome Statute, I raised the question as part of my master's thesis of whether this now meant that individuals could be victims of the crime of aggression under the Rome Statute of the International Criminal Court. And at the time, this question was received with a considerable degree of skepticism. And I was even told that the question was a non-starter because the answer was so obvious. But then when I inquired further, the scholars that I spoke to, the international human rights lawyers and the experts on jus contra bellum and aggression had come to completely different conclusions about what the answer was. The human rights lawyers told me that, of course, it's obvious that the individuals can be victims of this crime, whereas the jus contra bellum scholars said, of course, it's obvious that individuals can't be victims of this crime. So it was clearly an area of controversy, even if both sides of the debate were not yet aware that a debate actually existed. So I decided to pursue this topic in order to further explore this question. Perhaps I'll start by further highlighting what even makes this a question, because as Shane mentioned, the Rome Statute of the International Criminal Court contains significant restorative justice provisions. So it's the first international criminal tribunal to confer significant procedural rights on individuals who are victims of the crimes within its jurisdiction. This means that those victims have a right to participate in the proceedings, to present their views and concerns to the court, and importantly, the right to seek reparations from the convicted person. However, the crime of aggression differs markedly from the other crimes within the court's jurisdiction. So unlike war crimes, crimes against humanity, and the crime of genocide, individuals have never had a legal interest in respect of this crime. The crime is not based on any violation of international human rights law or international humanitarian law. It has at its core a violation of the jus contra bellum, the prohibition on the use of force between states. So never in the history of international law have individuals been considered direct victims of aggression, and they were not considered as victims of crimes against peace in the international military tribunals. Although individuals could seek reparations with respect to the Iraqi invasion of Kuwait and with respect to the Eritrea-Ethiopia conflict in those different claims commissions, they didn't have legal standing in their own right, but they had to present their claims through their state of nationality or through an international organization with respect to the UNCC. So by bringing this new crime within the International Criminal Court's jurisdiction, it raised this question. Principally because the crime of aggression contains as an element of the crime, of course, a state act of aggression. And aggression is the most serious and dangerous illegal use of force by a state against the sovereignty, territorial integrity, or political independence of another state. So in other words, the protected interest of the prohibition of aggression is the state, or perhaps more broadly, international peace, but certainly not the individual. And so this raised the question, can individuals be victims of the crime of aggression before the International Criminal Court? In analyzing the legal instruments of the court, I came to the conclusion that yes, individuals can be recognized as victims of this crime. And that's because of the way that victim is defined in the rules of procedure and evidence of the court. So it requires factual harm resulting from a commission of a crime within the court's jurisdiction. It doesn't require that the victim have been targeted by the perpetrator or have a legal interest. So in other words, even if you are not the protected object of the crime in question, you can still be considered a victim and receive victim status before the International Criminal Court. And this is a very significant development in international law. And as Shane mentioned, at the time, it seems to have passed by without much remark. There are some interesting legal questions which still remain open, even if the court is to adopt this interpretation of the legal text of the court. One of those questions relates to the required causal nexus. So who exactly can be considered a victim of the crime of aggression? And this depends on the causal nexus between the victim and the crime, so the harm they suffered resulting from the crime. Will the court restrict it to only those who suffer harm, for example, those who are killed in the act of aggression itself? In other words, for example, a bombardment of territory, or will they extend it to a wider temporal scope for the entire ensuing armed conflict resulting from this act of aggression? So would it also cover those individuals who are harmed or killed during the ensuing international armed conflict when the victim state exercises its right of self-defense against the aggressor? Will it cover those individuals who are killed also due to lawful acts of war, either by the aggressor or by the victim state? And will it also cover individuals who are killed due to other violations of international law? So those who are killed as a result of war crimes, for example. So it still remains to be seen how the court will actually deal with these questions if and when such a situation comes before it in the future. It's another question whether individuals should be recognized as victims of the crime of aggression. So Shane also mentioned recognition of individuals as victims of this crime could raise significant procedural challenges for the court due to the massive number of individuals who may be harmed as a result of aggression. It also raises challenges with respect to reparations, since as we've already seen in the other reparations orders of the court, the convicted person is unlikely to have sufficient assets to fulfill the reparations order, and this will transfer the financial burden of fulfilling the order onto the trust fund for victims. However, these are not principled reasons for excluding recognition of individuals as victims of this crime. They're not unique to the crime of aggression, but they're inherent in the institutional framework of the International Criminal Court itself and the very nature of the crimes within its jurisdiction, namely those crimes of the most serious concern to the international community, who have inherently or are likely to have very high numbers of victims. Perhaps a more serious objection could be that it seems that states didn't intend or even foresee that individuals could be victims of the crime of aggression, because during the negotiations for the Kampala amendments on the crime of aggression, it wasn't discussed how these victim provisions, or if these victims provisions, would also apply to this crime. And this could indicate really the intention of states, or the idea of states, that states are the victims of this crime and not individuals. And recognizing individuals as victims of the crime could therefore run into political opposition and further increase the reluctance of states to support, to put it mildly, the court's jurisdiction over the crime of aggression. However, there are also really important reasons in favor of recognizing individuals as victims of this crime. And one of them is that it allows for the equal treatment of victims of all of the crimes within the court's jurisdiction without making artificial legal distinctions based on which crime they've been victimized by. And given that international or individual justice is one of the key pillars of the International Criminal Court, it seems really important and it would be something beneficial if the court, as well as states, would support this development and recognize individuals as victims of the crime of aggression. So thank you for your attention, and I look forward to the rest of the discussion.
You can go ahead, Ilya. Good man.
Okay, thanks. Can everybody see my PowerPoint? Okay. Okay, great. So I want to thank the organizers for inviting me and previous presenters, which were amazing. I will go into more details about General Comment 36 that Shane and Aaron both mentioned in passing. And specifically delve into the deeper issues of viewing aggression as a violation of the right to life in light of General Comment 36. So let's begin with the traditional view on the relations between interstate force and the right to life. Sorry, I'm just taking time. Okay. So the traditional view, as Shane mentioned, is actually based on three propositions. One is because of the principle of belligerent equality, all killings that are permitted under IHL would be generally lawful under international law, even if they're results of violations of jus ad bellum. So this is one proposition. The second proposition is that killings that are lawful under IHL, targeting of combatants, civilians directly participating in hostilities, et cetera, are not violations of the right to life under international human rights law. And this is the famous ruling by the ICJ in the Nuclear Weapons Advisory Opinion. The third proposition is that violations of jus ad bellum are chiefly an interstate issue, right? They're an issue between sovereigns and exclude individual interests, as Aaron pointed out. So the result is that according to the traditional view, there is no real intersection between jus ad bellum and the right to life under international human rights law. This is a traditional view of the last decades. So what happens once Human Rights Committee GC 36 on the right to life enters the scene? So GC 36 in paragraph 70 establishes what I call three pillars. So the first pillar is that state parties engage in acts of aggression, resulting in deprivation of life, violate ipso facto Article 6 of the Covenant, right? So this is a negative duty towards non-citizens. And this means that killings in pursuit of aggression are violations of the right to life, even if they're lawful under IHL, right? Pillar 2 suggests that states are responsible to protect lives and to oppose acts of aggression. So this pillar actually imposes a positive duty towards one's own citizens to act, perhaps even forcibly, against aggression by other states. Pillar 3 is even perhaps more dramatic. States that fail to take all reasonable measures to settle their international disputes by peaceful means might fall short of complying with their positive obligation to ensure the right to life. So this is an obligation to take all reasonable measures to prevent wars. And states that don't take all reasonable measures to prevent wars, and these wars result in death of their own citizens, combatants or civilians, they might be perceived as failing to exercise due diligence to protect life. So common to all three of these pillars is that they challenge the traditional view that decisions on the resort to force should only be assessed on the interstate level. And I develop and criticize both in terms of theory and in terms of doctrine these three pillars in an forthcoming paper in the European Journal of International Law. It's available right now on SSRN. I will focus the rest of my presentation mainly on pillar 1. I will maybe say something about pillar 2 also. So before doing that, I want to highlight something interesting. So General Comment 36 if we look at the relations, the triangular relations between jus ad bellum, IHL, and international human rights law, so General Comment 36 actually establishes an asymmetric model of application, right? So concerning the aggressor, paragraph 70 applies, and this is really interesting. All killings are unlawful, even if they're not prohibited under IHL. This is for the aggressor. So what does IHL do in such a situation? It provides combatant immunity from prosecution to the soldiers themselves, but it doesn't absolve state responsibility under IHRL. What about the defender? So concerning the defender, paragraph 64 of General Comment 36 applies, right? So use of force consistent with IHL is in general not a violation of the right to life, right? Presumably the ICJ nuclear weapons formula is retained in such a situation. So here we have both combatant immunity from prosecution and no state responsibility under international human rights law. And this asymmetric model is something pretty novel for General Comment 36. So I want to say a few things about the practical implications of General Comment 36, and also a few words about what I view as the danger of the securitization of human rights. So I think Shane mentioned that first key implication is that international human rights courts might gain jurisdiction over such decisions, right? We saw that also in Georgia versus Russia too. Disregard the text on the left right now, right? So paragraph 28 to Judge Keller's concurring opinion in dicta mentions Human Rights Committee General Comment 36 as something that the court might have to look into in the future, right? We might have reporting requirements to treaty bodies on decisions to resort to force, something that we haven't seen until now. Mandates of Human Rights Council commissions of inquiry and special rapporteurs might opine on resorts to force. And Shane mentioned Agnes Calamard's report on the killing of Qasem Soleimani, paragraph 82. So she comes to the conclusion that there was a violation of the right to life of General Soleimani because the attack was presumably an act of aggression against Iraq. Right? Another implication is remedies for individual victims, and Shane mentioned that, and I won't get into that further. The question is whether this is a good or bad thing. So in the article, I develop kind of a normative discussion of this question. I think that the key concern is what happens to human rights law when it starts to make decisions and analyze questions of resort to force. And there is a concern that because of the indeterminacy of rights, human rights discourse will not, at the end of the day, serve to limit resorts to force, but will serve mainly to legitimate them. And this concern is especially pertinent when we look at Pillar 2, which establishes a positive obligation to oppose aggression. So now, if until now we can say that, well, the right to self-defense is something which is subject to the discretion of states, now states can say, well, you know, we have an obligation to resort to force to defend our civilians or combatants, which actually gives, you know, a very powerful legitimating language to justify resorts to force. And I think this is something that is usually overlooked when we think about human rights. I want to discuss in a few words some of the objections that states presented to paragraph 70, and Shane mentioned them. I want to focus on the objections by the United States because I think these were the most far-reaching. So one objection leveled by the United States was that the ICCPR does not apply extraterritorially. We know this argument very well. And if the ICCPR doesn't apply extraterritorially, so of course it doesn't apply to aggression because aggression usually takes place outside of the territory of the state. And this view was augmented in the recent decision of the Grand Chamber of the European Court of Human Rights in Georgia versus Russia, which ruled that there is no extraterritorial application of human rights law in active combat in the context of chaos. So before there is an effective control over territory and there's active combat, there is no extraterritorial jurisdiction. So if this approach is accepted, so this will quash the ability to apply General Comment 36, because of course aggression is something that is many of the killings in pursuance of aggression take place before there is control over the territory and in this context of chaos, as the European Court defines it. But I think this is ultimately not convincing, because I think this ruling is inconsistent with previous jurisprudence that views jurisdiction as possible also where there are effects on rights which are direct and reasonably foreseeable, even if physical control is lacking. So time will tell whether this recent interpretation in Georgia versus Russia will take hold or not. Another, I think, more interesting objection by the United States is that jus ad bellum is the lex specialis on questions to resort to force, and it displaces international human rights law altogether. And this might seem compelling at first glance, but I think it actually makes very little sense, because when does lex specialis come into play? When do we have one normative framework that displaces another? You need some kind of relations of conflict between these normative frameworks or specific rules. And this simply doesn't exist in the relations between jus ad bellum and international human rights law, right? So the application of international human rights law to situations of aggression does not conflict with jus ad bellum. It merely reinforces jus ad bellum by adding another layer of illegality, another layer of responsibility. So I think the lex specialis argument, as Aaron said in another context, is a non-starter in this context. The third objection is that issues of war and peace are the province of the United Nations Security Council alone. And we know, well, this argument is not widely accepted in the international community. We know that the ICC has jurisdiction over the crime of aggression. And also it's very unclear why should it be the case that the United Nations Security Council would be our preferable actor in this context. I don't think the track record of the Security Council in making such a determination is something that puts it in the best position to do so. So I think these threshold objections are ultimately not convincing. I want to raise several theoretical issues about Pillar 1. Okay, if we think that aggression is an ipso facto violation of the right to life, some very interesting theoretical questions arise, and these questions will surely translate into legal questions once this question, one of these questions gets to a relevant jurisdiction. So one, is it really true that all killings during aggression are arbitrary and therefore violations of the right to life, as the General Comment 36 suggests? I'm not sure, and I think one of the cases in which this question arises is the problem of what I call the defending aggressor. So we can think of state A attacking state B, and state B defending, and during its defense, it threatens civilians in state A. And state A, which is the original aggressor, now defends locally these civilians under threat. Can we say that deaths that are caused because of these acts of local defense of civilians are arbitrary under international human rights law? I'm not sure that this is the case. In the paper, I offer a possible solution to this conundrum. Maybe in the Q&A we can touch this, right? So this already sheds some problematic light on the sweeping language of General Comment 36. Another theoretical question is whether we can really say that defending soldiers are innocent victims. Because we know that there's a traditional view that all soldiers are actually dangerous people that can be justifiably killed, right? And this question relates to a very wider discussion in the ethics of war about the moral status of combatants. So in this context, and I'm not doing justice, it's a very complex argument, but just kind of to skim the surface, right? So Michael Walzer argues that all combatants are actually morally equal because they're mutually threatening, regardless of their cause, right? So if combatants are threatening by nature, can we really say that they're victims, right? So this is one traditional view. Another view presented by Jeff McMahon, and this view is known nowadays as a revisionist approach to just war theory, is that, well, you know, yeah, all combatants are mutually threatening, but the fact that somebody is threatening does not make killing them just, right? We have to look at the specific cause and why is that person actually threatening? So McMahon argues that defending soldiers, although they are threatening, remain innocent because they're defending themselves, right? So, and if this is the case, they remain innocent even though they're armed and dangerous, right? I think in actuality, we don't have to decide between these views when we look at GC 36, because human rights law claims are leveraged against states, not against opposing combatants. And nobody says that states are morally equal under jus ad bellum. So we can retain this perception of soldiers as morally equal if we want, without actually saying that, well, the state sending them cannot be held accountable under human rights law. So this is one theoretical question that is likely to arise that I think we can circumvent, and we don't have to really run into this wall. Another argument is what we call role-based objection. And this argument is, to put it simply, is, well, combatants cannot be victims because they waive their right to life, right? They decide, they consent or decide that they're joining a war effort, they waive their rights. This is part of their role as combatants. I think this argument also is not ultimately convincing, because there's always this problem of consent and coercion. Can we really say that soldiers consent to fight, right? And even if they do, right, does this consent actually alter their moral status and justifies waiver of rights? Very difficult questions. And two, and I think this relates more to the specific nature of human rights law, I think that international human rights law doesn't recognize consent as something that is valid as a waiver of the right to life. We know that the right to life is non-derogable in general, so I don't think that if states can rely on the consent of soldiers in this context. And in the few minutes I have left, I want to say a few words about aggression, the right to life, and other unlawful resort to force. If we look at Pillar 1 under paragraph 70, something which I find really striking is that General Comment 36 doesn't refer to all killings, killings resulting from all violations of Article 2.4 of the UN Charter, but only to those that result from aggression, which is the most serious and dangerous form of the illegal use of force. And then the question arises, well, if, other resorts to force that don't amount to aggression are unlawful, right? They involve taking of lives outside of a defensive context. Why is that not an arbitrary deprivation of life also? And I think there are a few possible answers, right? So one is the case of unilateral humanitarian intervention. And humanitarian intervention is interesting in this context because here we might have a use of force that might be unlawful under jus ad bellum, at least on the mainstream view. But still, when we look at the specific situation, the killings of combatants during humanitarian intervention might still be not arbitrary under international human rights law because they might be defensive. So we have a very interesting split here between jus ad bellum and between the right to life under human rights law. So this is one case. But I think it's more difficult to justify the approach of GC 36 when we think about other cases, such as frontier incidents, less grave uses of force, such as supporting rebel groups, or cases in which a defending state is using disproportionate force in response. This is probably not an aggression, but still unlawful. Why is this not an ipso facto violation of the right to life? And in my paper, I analyze this question, but I think perhaps what we see here is General Comment 36 reserving some space for politics and trying to limit situations in which resorts to force would actually make it to the human rights law level. Yeah, so I ran out of time, but hopefully we can address some of these questions in the Q&A. So thanks.
Thank you very much, Eliev, and thank you very much to Aaron as well for really going in a much deeper look at some of the issues arising in relation to developments at the ICC and developments in terms of the Human Rights Committee. I have a message from Bill Shabus, and unfortunately something has come up at very, very short notice, and he's not going to be able to join us, which is unfortunate as someone who has worked in both contexts and who has put forward ideas many years back that have been said to be influential in terms of some of the developments, particularly at the Human Rights Committee. We have around 30 minutes or so for questions, but also for comments. So in terms of the setup with this webinar, you can use the Q&A function if you want to type a question. You can also raise your hand using the raise hand function, and then I can allow an individual to speak and to raise the question or to make the comment. Unfortunately, you won't be able to turn on your microphones because it's a webinar setup rather than a meeting setup. I see we've many of our students in attendance, as well as various other experts and academics from around the world, including people with great expertise in this particular area. So be very interested to hear people's input, questions, observations on this topic. So let's open it up and take some questions or some comments from our attendees. Okay, I see a hand there from Dorhai. We might take a few questions and comments together. So we'll start first with Dorhai. Go ahead, please.
Can you hear me?
Yes.
Yeah, thank you. Thank you very much for your presentations. I have a question for Dr. Eliav Lieblich with regard to unilateral humanitarian intervention. And he mentioned that, sorry, the Human Rights Committee did not include other forms of use of force in order to kind of exclude unilateral humanitarian intervention. And I was wondering if he could maybe address the proposition according to which unilateral humanitarian intervention is indeed a use of force, an act of aggression, especially according to Kevin John Heller, who wrote on this topic thoroughly.
Okay, thank you very much, Dor. We'll put that question to Eliav. Let's take a few more questions if there are some. Ray Murphy, go ahead, Ray.
So Shane, thanks for really very interesting presentations and very insightful and very comprehensive. Mine's a really general question because of the recent case from the European Court of Human Rights. I'm wondering if anyone else finds the jurisprudence of the European Court of Human Rights on issues relating to international law, the use of force, and indeed international humanitarian law and related issues, so confused and muddled that it's difficult to discern a coherent jurisprudence that you can say reflects the view of the court.
Okay, thank you, Ray. We also have a question in the chat, which I'll read out, which is from Julia E. It says, questions, when do you think the ICC will have its first crime of aggression case? And will the court, in your view, focus on victims in this very first case? Okay, thank you for that question, Julia. So I might turn to Eliav first, given that you were asked the first particular question, which was in relation to humanitarian intervention. And I meant to say as well, both Aaron and Eliav have really demonstrated how the simplicity of, let's say, Rule 85 on who was a victim before the ICC and paragraph 70, they really belie the complexity of this topic. And one of the questions that I have, I was wondering when Eliav started speaking about those acts that don't necessarily amount to aggression, I was wondering to what extent developments at the ICC and the agreement on aggression may have influenced the Human Rights Committee, that it decided to focus solely on aggression, perhaps to buttress it, given that there had been that agreement at Kampala. But over to you, Elia, for the first question, and if you want to join in on the other two, go right ahead.
Yeah, thanks, Do. Yeah, I know Kevin's article. It's actually in the same symposium in which my article is coming out. So he argues that humanitarian intervention is an act of aggression and perhaps even the crime of aggression. And he makes a very strong argument. If he's correct, then so this example is probably rendered moot. Sorry. But I think this is still not the mainstream view. I think, according to most commentators, genuine unilateral humanitarian intervention, something that Kevin Heller thinks doesn't really exist, he thinks it's like a ticking bomb scenario, will not constitute an act of aggression because it's not this type of extremely grave violation of the law and the use of force, as we usually think of aggression. So it's interesting to see where this would develop, and if Kevin's argument will actually be widely accepted. Yeah, but it's a very interesting and thought-provoking argument for sure. Regarding the question about the ECR-HR being confused and muddled, as as an external commentator about the ECR-HR jurisprudence, I completely agree. I often, when I read these the rulings by the European Court of Human Rights, I kind of get what they're doing, but not completely. It's like, what exactly are they doing here? So I think you're not alone in this feeling, specifically concerning extraterritorial application, but not only. Regarding when will the ICC have its first aggression question, I will defer to others on this question.
Thank you, Elia. Could I hand over to you, Aaron, to get your thoughts on the question in relation to the ICC and any of the others you want to mention?
Okay, thanks, Julia, for this interesting question. As to when the court is likely to hear a case of the crime of aggression, it's really hard to say because the jurisdictional provisions which states agreed to set such a high threshold for when the court can exercise its jurisdiction over a potential crime of aggression. So it's still a bit contested exactly how to interpret the agreement that states came to, but on its most narrow view, it would require the aggressor state to have ratified the Kampala amendments on the crime of aggression and to not have issued a declaration opting out of the court's jurisdiction over the crime. So as Shane mentioned earlier, there are only 40 states parties which have ratified the Kampala amendments. And of course, they tend to be the states which are precisely those states unlikely to be committing acts of aggression. For example, Liechtenstein, Samoa, and so on. So from that point of view, it's unlikely that we would see a case coming through this means of either state referral or an investigation proprio motu by the prosecutor of the ICC. In my view, more likely would be that a case comes via Security Council referral, because in this case, the normal requirements for the court to exercise jurisdiction would not apply. So the court would be able to have a case regarding a crime of aggression, which occurs also on the territory of a non-state party or a non-ratifying state to the Kampala amendments. Another threshold which would have to be reached would be that of the definition of the crime of aggression, which is quite a high threshold. So states incorporated the definition of an act of aggression set out in the General Assembly resolution of 1974, setting out all the various acts of aggression, but it increased the threshold further by requiring an act of aggression, according to this list, which by its character, gravity, and scale constitutes a manifest violation of the UN Charter. So the intention behind this was to exclude so-called gray area uses of force, such as, in the view of some states, humanitarian intervention. So it would require quite a blatant act of aggression and probably UN Security Council referral for a crime of aggression to actually come before the ICC. When it does come before the ICC, or if it does come before the ICC, then individuals who suffer harm or believe they've suffered harm as a result of this crime would have the right to apply to the court for recognition as victims and to participate in the proceedings. And then the court would have to consider those applications and consider whether individuals can be victims of this crime and whether the individuals who applied are in fact victims of the alleged crime in question.
Thank you very much, Aaron. I agree with your analysis about the very high threshold of the definition of the crime, the jurisdictional issues. I mentioned in my presentation the question as to whether states might try and intervene in some way to narrow the focus, to prevent the court effectively from treating natural persons as natural persons as victims of aggression. But I'd be interested in your thoughts. My own view is perhaps that they wouldn't bother, that the states that are not interested in aggression being dealt with by the court will simply remain outside it, of course, unless the Security Council is intervening. We know the low likelihood of that happening if it runs up against one of the P5, one of their allies. But I think, back to the question, that if it does come before the court, and we can be surprised, the court has offered us many surprises over the years. I think the question of victimhood can't be avoided. It can't be avoided by the court or by the prosecutor as well. They have to pay attention to the interests of the victims from the very, very outset. In terms of the question from Ray about the European Court of Human Rights, I think, yeah, the Georgia versus Russia case certainly seems to add to the confusion in relation to the position of the court in relation to extraterritorial obligations. I think in some ways, and that's something that's mentioned in some of the partly dissenting opinions, pointing out the confusion that arises. It seemed that the court was moving away from Bankovich, that it was taking a more expansive view, but the majority here pushed back on that and got very highly criticized for doing so. It's not clear as to why they're doing this. I mean, as someone who looks at international humanitarian law, also I often think the court thinks about IHL's distinctions between situations of occupation or conduct of hostilities, but seems to neglect the fact that while IHL applies in all of those contexts, there may be particular rules that apply in those particular contexts, but it doesn't leave a vacuum. Whereas their approach seems to be one saying, well, when it comes to active hostilities, we're not going to apply. And even the fact that they say in the judgment that you can't have control over a person during situations of active hostilities is really very problematic. Just turning to some more questions, and we have a hand up here from Noam Nubel, and there's a quick question in the box that I'll just answer, and that was from someone asking if Professor William Schabas could not make the event, and that's true. He's not been able to attend at very short notice. Noam, I'll turn you on to allow you to speak there, and please go ahead. Great to hear from you.
Great. Can you hear me?
Yes.
Yep. Wonderful. Thanks for being able to ask the question. Hello to everyone. Nice to see a few friends together on the screen and to hear Ray's voice as well. Thanks for the great presentations. Aaron, as we recently exchanged in email, I was one of the professors when you raised this in your studies that was skeptical of the idea, and I must say I'm pleased to see how it's developed since, and all the presentations. A quick comment on what Ray was saying on the European Court of Human Rights in this area. I think this particular judgment that just came out on Georgia, Russia is an egregious example of some of the problems that come up. I think in a way it's an outlier because it is so ridiculous. Some of the reasoning there is inconsistent internally, with obligations to investigate something over which you didn't have an obligation, for example, something that comes up there. And I wouldn't be surprised if that changes. At the end of the day, it's a small number of judges, and there are many other judges that I think in future cases might change some of this, or at least I'd like to hope so. My question, I suppose, is more to do with the Human Rights Committee, General Comment 36, and really it's the fact that this blurring between the ad bellum and human rights law, and it has its reasonings as they put there, and as Bill wrote about in his Brace and Suspenders article that from a conference I was at in 2006. And I understand all the reasons behind that. I wonder whether there's a risk that this constant blurring between the different regimes, and maybe it's a good thing, but maybe there's a risk that it blurs other walls that we've tried to erect. And in particular, I'm thinking of the possibility that this is going to lead to holding individual soldiers accountable for ad bellum violations. Right, because once you start breaking down all of these rules, and once you start sort of moving between state responsibility and criminal law, I do see, and people have started arguing for this, and I just wonder whether any of the panelists have a view on is this something that's coming, and should we welcome it or resist it?
Thank you, Dome. We might take another couple of questions if there are any, please, before we go back to for answers. Ray, go ahead.
It's a more general question related to the use of force. Because I haven't read John Heller's or Kevin Heller's, more recent article, but if you accepted historically the concept of humanitarian intervention, which was kind of rephrased in the responsibility to protect, that there isn't enough legal basis to say that it constitutes customary international law. So therefore, logically, we must regard humanitarian intervention, unless it is actually approved by the Security Council, as to be illegal. So therefore, in all circumstances, it creates a situation of an act of aggression. Would that be, how would you and your other panelists respond to such a suggestion?
Okay, thank you, Ray. Any other questions or comments? Okay, thanks. We might go to you first, Eliav, if that's okay.
Yeah. Hi, Noam. It's great hearing you here. If there's a risk that GC36 blurs the limits of individual responsibility and will result in holding soldiers liable for use ad bellum violations, I don't think so. I think that GC36 doesn't challenge combatant immunity under IHL at all. GC36 applies to states, right? So you can leave combatant immunity and belligerent equality untouched, right? And soldiers belonging to both defenders and aggressors, as long as they don't commit war crimes, will enjoy combatant immunity from prosecution for merely participating in fighting. Whether this can be blurred in the future, of course, we cannot, be sure that it won't, but I think it will require a frog leap that is well beyond what the text allows. So I'm not too worried about that. If it'll happen, it will require really an interpretation that goes against the text. So this is one thing about Ray. I think if I got the name right, your question about humanitarian intervention, if I understood correctly, is, well, if there's no consensus that it's allowed and it's prohibited, so why isn't it an act of aggression? So, I mean, it's not a clear-cut question, right? But if we look at the customary understanding of what type of violation of the law and the use of force constitutes an aggression, so usually we think, and I'm quoting General Assembly Resolution 3314, the definition of aggression. Aggression is the most serious and dangerous form of the illegal use of force. So if we assume there is a genuine humanitarian intervention, meaning we have atrocities and the intervening state is genuinely attempting to stop these atrocities and try to get Security Council authorization and failed, et cetera, et cetera. So Kevin thinks this can't really happen, that this is just kind of an argument that we make to prove a point, but in real life it doesn't happen. There's no genuine humanitarian interventions. But if there are, I'm having a hard time to see if this, how this can be the most serious and dangerous form of the illegal use of force. It's just simply not the type of situation that we envision when we think about these dangerous uses of force. Right? Yeah, so turning it over to other panelists.
Thanks, Olive. And I think, I mean, if you look at it from the ICC perspective as well, I mean, humanitarian intervention, which is a label to describe a particular use of force, it depends on how that, if it is a non-genuine case, as was mentioned. So if you have a non-genuine case, then those high threshold criteria of something by its character, gravity, and scale constitutes a manifest violation, then I think it's something that the ICC would pay attention to. In relation to Noam's question, I think, again, the ICC approach here is relevant because it very much focuses the individual criminal responsibility for the crime of aggression on those that are really at the top inability to control the political and military apparatus of a state. It doesn't deal with anyone lower down, and I think that's important. It may be too high, it may be too narrow, but I don't think there was any sense that it should trickle down further than that. But I do agree there is an issue there because low-level soldiers involved in an act of aggression, individuals that may be killed in the course of that, those soldiers are involved of the deprivation of life in violation of human rights of those individuals, even if, as Elliot pointed out, the responsibility for that deprivation is that of the state. Whereas with IHL, it's more individualized, and if those violations are contrary to IHL, then that's a different story. But I think it's a very good point. Aaron, did you want to come in on any of those questions?
Yes. First of all, hi Noam, nice to hear you. And yes, of course, I remember very clearly that you were one of those who expressed skepticism about this idea back when I was writing on it in 2013, although you were also encouraging of my research. With respect to Ray's question about humanitarian intervention and aggression, I think this actually raises a really interesting point about the distinction between an armed attack and the concept of aggression or acts of aggression. So if there is no customary exception to the prohibition of the use of force with respect to humanitarian intervention, or if this customary exception is still emerging but has not yet crystallized, then arguably a humanitarian intervention is likely to constitute an armed attack under Article 51 of the UN Charter, because it would be a serious violation of the prohibition of the use of force. But it's not clear whether the same act, which is an armed attack, would at the same time constitute aggression as the most serious and dangerous illegal use of force. And this distinction has become more important, I think, because initially aggression had significance with respect to the Security Council being able to enact Chapter 7 enforcement measures under the UN Charter once it makes a finding of an act of aggression. It also now has significance with respect to the crime of aggression at the ICC, since a state act of aggression is one of the elements of the crime. And now we're starting to see that it can have some implications under international human rights law if an act of aggression is ipso facto a violation of the right to life. So when we bring in something like humanitarian intervention, which may be an unlawful use of force, and an armed attack, which could give rise to a right of self-defense by the victim state, it does raise some questions, or it highlights some of the differences which may exist between the concept of an armed attack and the concept of aggression under international law.
Thanks, Erin. Okay, let's take one more round of questions. I see Michelle has her hand up, and if anyone else wants to ask a question, please go ahead. So Michelle, go ahead there, please.
Hi, thanks for a great presentation. The question is for Dr. Aaron. It's just in relation to your thoughts on, I suppose, what are the practical measures that you see the ICC needing to put in place to deal with a potentially large volume of individual victims where the crime of aggression is has been prosecuted at the ICC. I'm just interested to hear your thoughts on that, and also in relation to how they can address the financial awards that need to be granted to victims if there's a deficit in the fund. Thank you.
Okay, thank you for this question, Michelle. So with respect to the kinds of measures that the court could take in order to facilitate participation by a potentially large number of victims with respect to the crime of aggression, they're, in my view, the same as the measures which the court is already implementing with respect to other crimes already, also within its jurisdiction. So these include measures like a common legal representative for victims. So you have one legal representative who represents the interests of victims, of a group of victims in the proceeding, and meets with victims collectively in order to collect their respective views and concerns in order to present them to the court as a group rather than individually. You also have the delegation by the chambers to the registry and also to the trust fund for victims with respect to processing the individual applications for recognition of victim status, requests to participate in the proceedings, and also recognition of victim status and application for reparations after the conviction stage. With respect to reparations, also the trust fund for victims can have a role and is playing a role with respect to consulting with victim communities and collecting the views of victims about different forms of reparations which they would like, including collective reparations.
Thanks, Aaron. And I noticed in the independent expert review that there was some very pointed recommendations towards the trust fund for victims in particular to focus on its mission as a trust fund, limited functions to fundraising, administration of those funds, and release of the funds as ordered by the court. So they have made some kind of strong recommendations as to how to streamline and improve the effectiveness of this system. But of course, I think the limitations of those funds will become evident. Now, they've talked about targeting private donors, including corporations and large foundations and non-governmental organizations as well. And it's clear that states haven't decided to fully fund the trust fund or the reparations process of the ICC, which could become evidence if we do have large numbers of victims in an aggression proceeding. Okay, one last ask if there's any questions or comments that anyone would like to make to our panel, or any observations people would like to make on this topic. Well, if not, then it's just up to me to thank our participants, our co-panelists for participating today, to Aaron and to Eliav for joining us. It's really been a terrific and a wonderful session. I'm sure Bill would have contributed as well, but unfortunately he wasn't able to make it. Thanks again to Courtney at the Whitaker Institute and to Catherine White for signing today's session. And thank you all also for attending, and do keep an eye on the Institute's website and the Centre's website for future webinars of equal, if not maybe a little less, but maybe some more interesting than today. So thanks everyone.
Thank you for having us.
Thank you.